Hello, welcome to today's webinar, Prepping for the California Consumer Privacy Act. I'm Nishimura, counsel at Atrium, and your moderator for today. Before I get into webinar logistics and introduce our speaker, I wanted to tell you a little bit about Atrium for those who are new. Atrium is a corporate law firm and technology company providing fast, transparent, and price-predictable legal and business services to startups through our technology platform and innovative subscription-based pricing. We're reinventing how professional services are delivered with a focus on improving the client experience. Now on to the logistics for today's session. This webinar will roughly be 45 minutes of content, followed by Q&A at the end if time allows. You can submit questions at any point during the webinar on the left side of your screen. And now that we've talked about logistics, I'd like to hand the mic over to Diana Maier, founding partner of Maier Law Group, to quickly introduce herself, and then we'll get started on the content.
Thanks, Kay. This is Diana speaking, Diana Maier. And I own a boutique data privacy and employment defense side employment law firm in Marin County, although we function really all over the Bay Area and beyond and have employees all over the Bay Area. And MLG, as we call ourselves, does advice and counsel in both these spaces, the data privacy arena and employment law. We defend lawsuits for employers, and we have a host of preventative services like workplace investigations, trainings, executive coachings, and we even do mediations in the workplace.
Great. Really excited to have you today.
Thank you.
And for today's discussion, at a high level, here's what we'll be talking about. Key points you need to know about the CCPA. Who does this apply to? How does it differ from GDPR? What does the law cover? What do you need to do to prepare for the rollout? And then we'll, of course, do some Q&A. Note that the guidance on the CCPA is still being finalized and will be released sometime in 2020 in final form. So to start, who does this law apply to?
Okay, so that goes to me. So the law basically applies to all for-profit entities that do business in the state with some particular characteristics. And first, I want to say that doing business in California does not equal being located in California. So you can do business in California because you have a large amount, you have sales here, or you have employees here, or you have an office here. There's a whole bunch of ways that you can be located in California. Incidentally, this is not defined in the CCPA. This is defined in the California Civil Code, but I'm just kind of reiterating that here so that it's clear that it's not just for those that are established in California with all their functions happening in California. And it's also important to note that the CCPA does apply to B2B or business-to-business organizations. So even if you're not doing what you think is traditional consumer, mining kind of traditional consumer data, if you're handling the data of a number of businesses, the individuals in it and their emails or that kind of information, you can become subject to the CCPA. So it does apply to business. The other things that you should know have to be in place or have to occur for you to qualify for compliance is that you have to be what we call a data controller, or the person that collects the consumer's personal information, which means that you determine the means of processing that PI. In other words, you're the initiating force for gathering that data. You do business in California, as we said. And then one of these three tests, you have a gross annual revenue in excess of 25 million, or your company annually buys, receives, sells, or shares the personal information of more than 50,000 households, consumers, or devices. So that's important because you could be a single household or a single person with theoretically, 15 devices. There are some people out there like that who have that many devices. And if you have a lot of people like that in your constituent base that you're going to become subject to the CCPA, even though it may not be readily apparent just by looking at your consumer numbers. And the other way that you might be forced to comply with CCPA, even if you're not what the law calls a covered business, is if you share a brand with a CCPA covered company. So you have some kind of mutual ownership and share a brand, or you're a service provider. So you process info on behalf of a covered business. And you will generally have to have some kind of a contract in place that will affirm that you take this information in, that you only process it for the purposes for which the covered business tells you to process it. And then, of course, if you get a request to delete certain information or get access to certain information, you're going to have to comply with that as well. So there are a lot of different ways to comply, even though there are a lot of different ways to be eligible, even if on the face of the statute you don't meet the test.
Can I ask a quick follow-up question?
Yes.
So when we're talking about the 50,000 California consumers, what do we mean when we say consumer? Is it just the customer of the company, or are we talking about a broader range of people?
Yeah, great question. So you are talking about a broader range of people. So this is a little bit complicated because it used to be, or it was until AB 25, which was an amendment to the bill that was passed recently, that it covered that employees were also considered to be consumers and contractors and things like this. That provision has been, there's an exemption that has been drafted and has passed that now says that businesses can temporarily exempt employees and contractors and the like from that definition of consumer until January 1st, 2021. And at that time, there's an expectation. What will more likely happen is that there'll be a new bill that deals with things like employees and contractors and things like that.
So it sounds like the answer to the question is right now it's a broader subset than just what our clients may think of as customers, but the regulation isn't 100% solidified yet. So we'll need to discuss it at a later time when we have more guidance. Is that right?
That's right. And of course, to keep in mind that, as I said in the beginning of the slide, your consumers could be a business to business. So it might be your consumers quote unquote might be, a contacts at other businesses, and you have their name and email addresses. That could be a consumer. So it's not in maybe the traditional way you think of a consumer.
That makes sense. And I think for me as counsel at Atrium, one of the more common questions that I get off the bat is, how is CCPA compliance different from GDPR compliance? Can you go through a high-level overview of how similar or different they are?
Yeah, absolutely. And in the next slide, we have this handy-dandy chart that Gabby prepared for us that shows kind of the key areas that both laws govern and the ways that they're alike and different. The red obviously being areas where they're very different. And as you can see from the lack of green, very few areas or no areas where they overlap exactly. The yellow and orange, there's a fair amount of similarity. So that's what that is. But rather than going through that point for point, I just wanted you to have that information should you need to go back and reference it. I'm just going to talk at a high level about how the bills are alike and how they're different. So both the GDPR and the CCPA are fairly groundbreaking laws. The GDPR is a much more comprehensive law, but some would argue that the EU is far ahead of the US in terms of privacy protection. So for the GDPR, that was, even for the EU, a pretty groundbreaking law and very comprehensive and governs all of the various states of the EU. And the CCPA is likewise fairly groundbreaking. It's definitely the most protective bill of its kind right now dealing with consumer information. And there's an expectation that other states will have a similar kind of law at some point. So some of the key differences are that the GDPR is more focused on accountability. It appoints a data protection officer. It goes through a record of your obligations and requires that you keep notes on all the times that you've obliged with requests on your data. And the GDPR is very comprehensive in the kinds of data that it covers. It basically covers almost everything. The CCPA, by contrast, excludes certain kinds of data. So protected health information or financial data that is covered by other specialized laws that regulate those areas are generally exempted. And CCPA focuses a lot on transparency and provisions that limit the selling of personal information. So I would say those are the key ways that they are alike and how they're different. I will say, because I know another question I get a lot is, well, if we've complied with GDPR, if we complied with CCPA, well, not exactly. But generally, if you've gone through all the work to comply with GDPR, you're off to a really good start. Most of all, you've probably done data mapping. You've looked at where all your data lives, and you've looked at all the data that you have and where it goes and how it travels, those kinds of things that are so important to understand when you're drafting a compliance plan, either from the GDPR or for the CCPA.
That makes sense. And I know we're going to cover some best practices at the end, so we'll circle back to that.
Yeah.
So getting into sort of the details of CCPA, what data does it actually regulate?
So the CCPA regulates personal information, or PI, and the PI is defined in a way that is extremely broad. We have the definition in the slide, but it's anything that identifies, relates, describes, is capable of being associated with, or could be reasonably linked directly or indirectly with a particular consumer or household. And as I said before, it does regulate business information, not just personal consumer information. So this is a really broad definition because you could have something, for example, like a physical description of somebody, and that can be personal information, because if you have enough of that, you could identify someone. So it's a much broader interpretation. It's a much broader definition than even GDPR and than pretty much any other privacy law I know of in the United States.
And so going into this chart, which we've prepared, are there any things that our customers, our clients should really be thinking about that may not be intuitive?
Yeah, I mean, so this chart is basically, so the A through K on the left are basically words that are used in the legislation. This is how the CCPA classifies essentially various kinds of personal information. And then on the right, we gave some examples of that. So you get a sense, but I mean, there's all kinds of things. Like if you look at commercial information, there's, shopping tendencies in there or something like that. What does it say? Consumer histories or tendencies. So, and that might seem like not such important information, but I think one of the reasons that this bill regulates it is because what you're seeing is that with more and more data analysis, that even information like that can be used to both identify individuals and to identify really personal pieces of information about individuals. So a story that I really like to tell when I'm talking about the importance of privacy is about big data and how big data has been used to extrapolate really intimate details about people's lives. And there was a example I give, which is a real example, which happened in 2015. There was a man who went to Target, and he had some coupons that he was holding up of diapers and wet wipes, and they were being sent to his daughter, who was still in high school. And he said, "What is the big idea? Are you trying to, you're trying to give my high school daughter ideas, And the manager was profusely apologetic, and he went home. And a few days later, the manager called to apologize again. And the father said, "Actually, I owe you an apology. It turns out my daughter is pregnant, and I didn't know." And essentially what happened was that Target was discerning that shoppers that were, when they were pregnant, they found these really interesting tendencies of the women that were shopping. So they would buy lots and lots of body and hand lotion. I'm not sure why that is. Maybe like when your belly gets dry, your hands. They would buy a lot of hand sanitizer. They would buy, of course, supplements. And so they actually got to the point where not only could they tell if someone was pregnant, but they could even predict a due date within a few days. So they have all kinds of really intimate information. So this young woman, all they really knew about her was probably her name, her shopping tendencies. But from that, right, they realized if they sent her coupons for diapers and so on, well, those would come in handy and she might come in and shop. And of course, that is what, let the cat out of the bag with when it came to her father finding out about the pregnancy. So this information on first glance doesn't look, and it is a very broad law, maybe too broad in some ways, but there are reasons that such information is regulated.
So now that we have a better sense of the data that's regulated under the law, let's talk about the second piece, which is what rights do consumers have under the law with regards to corporate data?
Yeah. So consumers can request that the business, disclose categories and specific pieces of PI. So for example, a category would be what we just talked about, that you have a list of their shopping tendencies, and the piece of information would be, you on such and such a day, you came into the store and you bought X, Y, and Z. It can also request that the business, disclose the sources from which the personal information is collected, like a website or some other route. And it may ask why the business is collecting or selling the personal information. It will ask or may ask who you are sending this information to, any third parties. And it can request that personal information be deleted. There are some exceptions to that, though, and those exceptions are, not insignificant. So there are all kinds of reasons that you can refuse to grant a deletion of that information, but it can be requested, and in some cases, it needs to be honored. And finally, if the consumer requests it, you absolutely must comply with the obligation not to sell their personal information.
So what and when do companies need to prepare?
Yeah, so before we go into the what, we'll talk about the when. And so the AG's office proposed some regulations that were pretty helpful because there was a lot of uncertainty about the law. That was in October. They took public comment on those until early this month. And right now that's all under advisement. The Office of Administrative Law has 30 days to look at that, and then either the regulations will go into effect, or they may decide that they need another round of, they need some new regulations and they need more public hearings. So it could be a while, but either way, enforcement of the law will start in July. So the law goes into effect on January 1, but enforcement of the law will start July 1st, 2020. Now, that's not to say that you don't need to worry about it until July. I highly recommend that you are worrying about it now. Ideally, you've already got some things in place, but if not, fortunately, you do have 7 months to get some things in place. But even the Attorney General has said that if there's some kind of a complaint about compliance, they will look at what companies are doing right now before the law is being enforced to see how well they're complying or their efforts to comply when considering if they need to assess penalties. So the Attorney General is going to look and see what companies are doing to get into compliance, even though the enforcement is delayed because essentially the law becomes law on January 1. So, and there's a lot to do. I think one of the key things to think about doing is a data map, and that takes a long time, or it can take a long time unless you have a relatively unsophisticated amount of data and it's housed in not a very sophisticated way. Then you might know fairly easily where everything lives and what you have. But otherwise, it can be a long process. So getting into compliance now is a good idea. knowing that enforcement's going to happen soon.
And for our clients who are new to data privacy best practices, what does it mean to have a data map?
Yeah, so data mapping is basically a list of all the data that you have, and so where it lives, what data you have, on who, where it lives, how it's stored, who it's sent to, so all the times it's in transit, even could be, what, when you delete it, how long you keep it for. So really the whole life cycle of data from its birth, if you will, when you collect the data, to its death, if you will, when you delete the data. And you need that for all your consumers or anybody who might make this kind of request for you. It's a great thing to have anyway. I mean, it is a really valuable thing for a company to have for a whole bunch of reasons, but this is one really big reason to have it.
In your experience, do companies handle this sort of data mapping exercise internally with, for example, a CTO or a chief information officer? What if you are working with clients who do not have the internal resources to handle that kind of data mapping project? Are there third parties that can help with this?
Yeah, absolutely. There are. And I've looked at a lot of those third parties. I've kind of come to have my favorites, and I've come to find out who's more affordable than others. Some businesses choose to do it in-house, and if you have a good IT department and they already have a take on that information, then it might make sense for them just to simply update it and amend their current data map. But a lot of times businesses just don't want to deal with it. And it can be really helpful to have a third party come in because they're a nice neutral outsider. They'll basically interview a whole bunch of people in order to determine the life cycle of the data. And that way they get kind of a snapshot from the macro perspective as opposed to the inside of the company, from the inside of the company.
Perfect. Is there such thing as getting like CCPA certified? Is that a concept?
Not that I know of. You mean in terms of your data mapping? And not that I know of. I think you can submit anything to the AG as part of the CCPA, and the AG will weigh in on it for you. That's one of the things that it has said. But do you know anything about CCPA certification?
It's not a concept that I'm familiar with, but I also am not surprised given that the law is still in flux, right? So I'm not really sure if any company would be able to point to all the components and declare a company CCPA certified.
Yeah.
That's sort of my initial thought.
Yeah.
Okay. So given the fact that there are a lot of individual and consumer rights associated with this law, and just to recap, consumers have a right to know what kind of info that a company has, where the company got it, where the company has sold it. Consumer can ask for a copy of all the personal information that a company has. Consumer has a right to tell businesses to delete any personal information. The consumer has a right to opt out of sale of data about them. Quite a long list of things that the consumer has a right to do. How do you tackle compliance as a company? Where do you start?
There's, like I said, I think that there are a number of things that you can do to prepare.
And sorry, I realized I'm poorly moderating. We skipped a slide about what the penalties. So maybe we back up, talk quickly about what the penalties are for non-compliance, and we'll get more into the discussion.
Yeah, so basically the penalties for non-compliance, they're steeper if it's intentional. So you got $2,500 per violation of the CCPA and penalties from the AG's office. But if it's intentional, and per violation is like per record, so you could have one consumer and many violations. And then if it's intentional, so you get notice that you're out of compliance and you have a 30-day opportunity to cure, and you don't fix it, then you've got a much steeper penalty, 3 times as large, of $7,500. And then there is a consumer right of action where consumers can recover up to $750 per consumer per incident, or the actual damages, whichever is greater, when their data is leaked or given away when it shouldn't have been. And so, for example, you might have a case where somebody's financial information is stolen and there's some kind of fraud that's committed on with their information, and maybe there's a few $1,000,000 in damage. Well, you would be liable, you as the company would be liable for all of that. So there's a number of different ways to look at it. The other thing that's important to know is that the CCPA doesn't create any new data security requirements, but because it does have this private right of action for data breaches, it's really important to take a look at your security and make sure that it's all tight and well done. And again, that's another good reason to do your data mapping, is that it will generally expose areas where you're particularly vulnerable. Either you have particularly sensitive information, or you're being kind of lax in how you're passing it on. You're not securing the data before you send it, things like that.
Got it. And actually, that's maybe even a better segue to talk about what do we need to do to prepare, especially if we are a smaller client, a smaller company, and you don't think you're implicated yet with CCPA.
Yeah. And actually, I just want to say one more thing, Kay, before we go into that. I think this private right of action is something to highlight, because a lot of other privacy laws do not have that. Like if you look at a law like HIPAA, for example, that's moderated by a government or enforced by a government agency, and a company can be called out for violating it, but there's no private cause of action. And even when you've seen in the past, like when Target had that, poor Target, I keep picking on them, but Target had that big data breach. I mean, there's been all kinds of them that happened now, gosh, I don't know, maybe 8 or 9 years ago. There was a whole bunch of class actions filed, but there was no direct cause of action. So that dealt with the breach itself. They would argue things like unfair business practices and things like that, saying that they didn't adequately secure the data. So they were using this data for business practices without adequately securing it, leading to harm and negligence and things like that. So this is fairly groundbreaking in that regard.
I think that's a good point. As a corporate attorney, we don't really see the litigation pieces all that much as you do, but I do think that the possible penalties that could be incurred as a result of non-compliance with CCPA could be pretty substantial, such that I would not be surprised if data privacy and privacy policies internally become a bigger issue and highlighted in things, in transactions and in diligence. So I would expect to see a trend, especially in the VC world, of reps and agreements getting bolstered to account for CCPA for venture capital funds and other investors to really start pressuring companies to comply sooner rather than later as a risk mitigation strategy.
Yep. Interesting. So there's a lot you can do to prepare, and these were just a couple of things that are some of the key requirements of the law, but you're going to need an online privacy policy that, and you can, if you have an online privacy policy and it's pretty good, it's up to date, and you really spell out the information you have and how you use it, that will be a good start. But you got to update it, make sure it's current, and you've got to identify in there what kind of information you collect and in what categories, how a consumer would request to exercise their rights under CCPA and so on. So there's a number of things that need to be included in that online privacy policy. And then you do have to have on your website a do not sell my personal information link where someone can opt out of you selling their information. It's important to note that selling is basically giving that information to a third party for any kind of benefit. So no money needs to change hands, but if you get some kind of benefit as a result of passing that information on, then you are selling under the law. So I do want to point that out. Then another thing to think about is that whenever you're passing information on to vendors that are handling it for you, you've got to have, they've got to be able to reassure you that they remain in compliance with CCPA, and you can actually, as the company, shift liability to them if you want through an indemnification clause, which is probably a great idea for most of the companies, I imagine they're listening to this, is to have a clause in there that says you say you're complying with the CCPA, and if there's any liability caused by your actions, violations, related to the act, that you indemnify us. So, because the vendor has to be ready to, if you get a request to delete data or a request for what data they have, the vendor's got to be able to respond to that. So you've got to have that in your contract. You've got to have in the contract that the vendor is only going to use this information for the processes for which you, the company, send it to them, and not for other reasons. And then another thing to think about is that certain employees will need privacy training. I think a best practice is to train all your employees in data privacy and security. We do kind of a data privacy and security 101. Something like that is what I'm thinking for all employees. I think it's really helpful when you start to look at these private causes of action that allow a consumer to recover when there's a breach. Well, that can go through many, many people, and it's just a really good idea to raise the bar on the knowledge that your employees have about data privacy and security, and, things like phishing and scam emails and things like that might open up weak links in your system. But basically what the CCPA actually requires is that employees that are dealing with the personal information of employees, that such people are trained and know how to tell consumers how to exercise their rights under the CCPA. So can guide them as to the steps that they need to take to request information on that themselves or delete information and so on. There's a whole other list of things that, I would say are really important, like drafting a written description of the consumer request submission process for publication on the company website, things like that. Getting your internal procedure in place for fielding, researching, and responding to consumer requests. So if you just think about what those three things require and all the things, what it's going to require for you to be able to carry out your obligations, then there's a number of action items that fall under that as well.
So in order to give our clients a little bit more specificity on the consumer verification piece. So let's say, a consumer reaches out to one of our clients and says, hey, I want to know what information you have of me. And being on the front line, the customer service representative responds back, okay, happy to help you with this request. What are the things that a company should be doing to sort of verify that the consumer is who they say they are? What are some things that they could do?
Yeah. So generally what you're going to do is you're going to take data that the employee has or knows, because it's about them, and you're going to match it with data that you already have. And there's some guidance about how many pieces generally, but generally the rule is that you should know that the person who's requesting it is who they say they are with a reasonable degree of certainty. I should say that's for if you're getting the category of data. Like if somebody writes and says, I want to know what data you have, and you write back and say, I have commercial data on you, I have, household data on you, and so on. But if you're going to give them very specific pieces of information, there's certain kinds of information you can't give them, like Social Security and things like that could be used negatively. But if you are going to give them other pieces of data that are very specific, then you actually have a heightened, there's a reasonably high degree of certainty. And generally that will require something like matching 3 pieces of data with the three pieces of data that the consumer has. But of course, it's going to depend on how good the information you have is. So if you ask them something like a street address, and their address is 5 Oak or something, that's going to be easier that's not going to be as unique as something that is much more unique to the person, like, or a maiden name, something else that's much more unique to the person. If they live in, and they have some kind of a funky address, or, anything you can think of that is much more specific will be considered, more helpful in the verification process. So, and then generally you have 45 days to respond to such a request. And if it's needed, you can get another 45 days, but you need to let the consumer know that there's going to be a delay and why there's going to be a delay. Also, you do have to provide, the CCPA requires that you have a toll-free telephone number that allows them to make a request. And if you maintain an internet website, then you've also got to have a website address where people can go and make this request. So again, there are a number of exemptions from this. I'll just say talk about those exemptions. The exemptions I want to say, are pretty broad. So, if an employee asks you to delete information and you need that information to perform a contract between yourself and the consumer, you can deny the request. If you need it to detect security incidents or for some kind of security, you can deny the request. You can deny it if the information is being used for purposes that are reasonably aligned, this is a quote, with the expectation of the consumer based on the consumer's relationship with the business. And you can otherwise use the consumer's personal information internally in a lawful manner that's compatible with the context in which the consumer provided the information. So I would think that an example of that would be to finish, carrying out an order or things like that. Let's see, what else did I want to say here? I think one other thing I want to say is that as a general rule, request to know and request to delete, request to know information that a company has on them and request to delete, and a request to opt in for sales, those all require the verification of the consumer, but a request to opt out do not. So that can always be done without verification. Here's the language. I'll just say this, that when it says, the bill says, whenever verifying the identity of a consumer or business shall, whenever feasible, match the identifying information provided by the consumer to the personal information of the consumer already maintained by the business, or use a third-party identity verification service that complies with the requirements for verification. And you are to avoid collecting certain types of personal information. Like I said earlier, some of those really tricky ones, unless necessary for the purpose of verifying the consumer. Like you don't have access to other kinds of verifying information, or you need a really secure, highly individualized piece of data.
So I think we've talked about a lot of potential ways that a company might want to kickstart their preparations for the rollout of CCPA. Once the law rolls out and you have a few of these things in place, what are some of the best ongoing compliance practices and the timing for which they should be thinking about those?
Yeah, so again, just a flavor of some here. There's a lot, but I'd say that one of the big things that you should do is, if you're not in compliance with CCPA now, but you think you might have to be at some point, to really keep track of where you're which of those three aspects, the $25 million in business, the $50,000 consumers, devices or households, or over half of your income in selling data, which of those three is going to where are you going to cross the threshold first, and to really be monitoring that and keeping that up to date and keeping your eye on it. So that would obviously be a a really important thing to do. The other thing is you might sit down and think about, well, I don't know if I'm ever going to get there, but I know that at some point I might want to process information or receive information from a covered business, or I might want to be doing business with a covered business. And so I may need to be in compliance with CCPA that way. So kind of thinking about all the ways that you may need to or want to be in compliance with CCPA and when that's going to happen, and monitoring that closely. And then, of course, we talked about the data map, but really making sure you're on top of where your data is, what it is, how it's being collected, where it goes, and when it's deleted, and making that, keeping that up to date, which is going to require, you're going to have to revisit it pretty much every month or so. As you get new software and delete old software and do new things with your data and that kind of a thing, and take in new people. And then I would say make sure that your current privacy policy is accurate and relevant, just because that, like the data map, will give you a really good jumping off point when you're updating that policy to make it compliant with CCPA. And you can also, if you like, on your site, you can have your standard privacy policy and then say, and sometimes I find this is less confusing, is if you then say, if you are a California consumer or resident, and please click here for more information about CCPA, our CCPA obligations. So you can have your CCPA compliant policy separate from your current privacy policy. And just like you could do a GDPR policy that's separate from your kind of standard privacy policy. Or you could try and maybe do it all in one document, but it might be a little bit cumbersome. And then finally, as I said before, it's a great idea to train all your employees on data privacy and security, just because you never really know who's going to be the weakest link in your organization. And so it's a good idea to train all your employees. If you're going to do it anyway for the employees that are dealing with important data, you might as well do it for everyone. So those are some key things. Again, I think, there's a much longer list here of kind of best practices, which I can give you, but I think these are a good start, and these are kind of the key areas where compliance is going to be focused.
So I think that sort of brings us to a conclusion of our planned content, but I have a few questions from our audience. And I think the first one is to just quickly recap what the small business exception to CCPA is. So I'll handle that one.
Okay.
Generally, a friendly reminder that the CCPA does have a small business exception to it, meaning that it does not apply to you unless you have annual gross revenues of over 25 million, or you handle the personal information of at least 50,000 California residents, or your company derives 50% of revenue from sharing California residents' personal info, or you are affiliated or aligned, and by that we mean share brand, etc., with a business, with a different business that meets any of the criteria that we talked about. So has annual revenue of over 25 million, or they handle the personal information of 50K residents, or are in the business of deriving revenue from the selling and sharing of California residents' personal info.
Yeah. And I just want to reiterate again that 50,000 number can be consumers, households, or devices. So again, you can get to that number. You might only have 20,000 consumers whose information you monitor, but between them, they have 50,000 devices. Well, you're going to be on the hook for compliance with CCPA. But I think that the small business exception idea is just that, these are generally going to be businesses that are either really involved in the data space, doing things with people's data and selling it, or they're going to be larger. I also want to note that there's an exception for nonprofits.
Great. Another follow-up question we had to content that we addressed earlier is, if a company has a website, then we made clear that you have to be able to request make requests per CCPA through the website. Is it also a requirement that the company has a toll-free number?
It is also a requirement that the company has a toll-free number, yes.
So if you are a company that has a consumer-facing website then you must have a link on your website that allows for the consumer to make direct requests to you via that link, and also a toll-free number. Is it a requirement to have a third method?
Yeah, you have to have, so what the law requires is that you have at least two methods, and then it also has these additional specifications of, that you've got to have a toll-free number where people can exercise their rights that way. And I think the general guidance is that you want to at least have one method that's kind of in line with how the information was collected in the first place. And that's why, if you have a website, the idea is that a lot of times the information is collected on the website. So you want to have right on the website the information about how you exercise your rights under CCPA.
Got it. One of our webinar participants is asking if there is a short list of points that we can provide that is sort of a cheat sheet for what needs to be included in any privacy policy update if they were going to take a first crack at it themselves. The one thing that I know most privacy policies need to reflect is that it needs to tell the consumer about their rights under this law and how to exercise them. I know that that's a required component that most privacy policies before the enaction of this law would not have, but need to have going forward. Is there anything else like that?
So I think things that you should put in there, you have to track what information you generally collect and what categories it falls under the CCPA. You've got to have a description of consumer rights. You want to have a written description of the consumer request submission process for publication on the website. Generally within the privacy policy is a good idea. You want to talk about what are your purposes for sharing or selling the information. You might go so far as to talk a little bit about your internal procedure when responding to consumer requests under the CCPA. Let's see, what else? You don't need this in your privacy policy, but like I said, you're going to have a separate link for a do not sell my personal information. I think, though, those are pretty broad categories that if you're going to be telling consumers how to opt out in that privacy policy, and that's going to require and how to exercise their rights, and that's going to require going into quite a bit of detail on what information you have and what they need to do to get in touch with you.
I think generally we at Atrium would recommend that if you feel that your privacy policy is not up to snuff, given these rolled out changes, always a great idea to reach out to your Atrium attorney who can set you up with a privacy specialist to review the document. We do know that a lot of our clients' privacy policies are quite angled for our clients' purposes. And so there's not necessarily like a basic privacy policy that a lot of our customers have or our clients use as a baseline. So to the extent that it's personalized to your company and to your services, you should definitely have someone look at it.
And always say in your privacy policy when it was last updated and where people can contact you if they have questions. But generally, I will say that updating your privacy policy is a good idea for compliance with other laws in addition to compliance with CCPA. So it might just be a good to-do item to put on your to-do list after the new year, maybe, if things are crazy until then, and roll it out, because it will be really helpful to comply with other laws in the online privacy space.
We talked a lot about training employees to be aware of these laws and to make sure that these best practices go from top to bottom in your company. When choosing a company to help you train or to teach your employees about this area, what are some questions that we should be asking of that service provider to ensure that the training content is adequate in the eyes of the CCPA statute?
That's a great question. This is all just one caveat. This is all so new, that so that there's probably no there's probably no clear-cut answer yet in terms of, I mean, as I said, there's not a whole lot of information on exactly what employees should be trained in, other than that they need to be able to tell consumers how to exercise their rights. I suspect that the AG will come out with more details on what should be in the training, but I think, generally finding any kind of a company that has done these trainings a fair amount and seeing how well they know the CCPA, if they've done other trainings with the purpose of getting into compliance with CCPA, asking them, how well they know the CCPA, do they keep on top of the developments with it. It can be helpful to just hear in general about their understanding of compliance with overall privacy laws, because sometimes the trainings that you'll get will just go through like, okay, this is how malware gets uploaded onto your computer or downloaded accidentally. This is how you can avoid spam emails. And not every IT professional or firm that does trainings, for that matter, law firm that does trainings, really kind of puts the two together and understands how the data security meshes with their requirements. So making sure that they have some savviness about those requirements, I think, is important.
Next question. This is from one of our clients who is wondering what our thoughts are on whether the AG will retroactively enforce CCPA violations or missed requests, especially during the grace period.
So there is a provision in the CCPA that requests for data and to know, and deletion of data that can go back as far as a year. So that's the other reason you want to get into compliance as soon as possible, is that you need to know not just what data you have to, what data you're going to have next week or in July, but you need to know what data you have today and what data you had 6 months ago, essentially, on that person, because all that information may be information that you need to disclose. So in that way, the law already does apply to prior to the date of its passage or enforcement.
Got it. And last question, because you're a litigator, I think you have some sense into this. So how likely do you see a scenario where an educated troll targets a business with threats of CCPA action? This client specifically, is paralleling it to patent trolls who kind of file litigation like this, or if you're in an industry where, ADA compliance is really big and class action attorneys are always eager to get a bite at the apple. How do you see sort of this trend playing out?
Oh man, that's a great question. But it's a little hard to predict the future. I mean, I think I think it's a concern. I think that the class action idea is certainly a concern, and I think it's just going to we're going to have to just wait and see how it's being enforced and what the courts are finding in those kinds of cases with the private cause of action. Keep in mind, though, with kind of individuals, you've got to have a breach of data. So, and you've got to have some kind of evidence that data was exfiltrated in some way before you can have, a valid cause of action. So that will, I think, head off that problem to some extent. But I think anytime you're dealing with these kinds of regulations, that's a concern. I think that's a concern in the employee space that happened with GDPR, which lots of employees posited that maybe there was a violation of their privacy, and so brought some kind of action for that, even though they really didn't have any proof of it. And that it just, even though they might have ultimately prevailed, the business might have ultimately prevailed, it just really mucked things up enough. And that's essentially, I think, what the employees wanted. So I think it's an issue. How much of an issue it will be remains to be seen.
All right, so we're running out of time. On behalf of the Atrium team, just want to say thank you, Diana, for joining us. And thank you to all of our participants who logged in today. I hope you found the information helpful. If you have any feedback on this session or questions for your legal team, you can always feel free to reach out. Feedback on this session should go to hello@atrium.co. And of course, if you're a current client, you know how to reach your legal team. Again, thanks so much for being here.
Thank you, Kate, for having me.